In this video, I will briefly discuss 4 methods of protecting jewelry designs in South Africa, namely patents, copyright, trademarks, and design registration. Thereafter, I will also glance at the ways in which traditional jewelry is protected in South Africa. Jewelry designs can be protected through the use of patents by using the Patents Act 57 of 1978. This act protects inventions and matters concerned therewith. It is recommended that patent protection is only used where the design includes a newly developed or improved technical component. The disadvantage of this means of protection is that since it must be proven that the design contains a newly developed or improved technical component, it presents the applicant with a high burden of proof. This means that you will need very compelling evidence to convince the court to decide in your favor. Jewelry designs can also be protected through the use of copyright in terms of the Copyright Act 89 of 1978, which protects original artistic works, including jewelry. An infringement of copyright happens when the core identity of the artistic work can be identified, even if certain aesthetic alterations were made to the work. It is recommended that copyrights only be used when the artistic work is original and produced by the artist themselves.
Copyright can subsist in the jewelry itself, as well as all drawn designs of such jewelry, in the form of artistic works and works of craftsmanship. Copyright subsists automatically and does not need to be registered in order to be protected. Therefore, you will have a right upon the existence of all requirements of subsistence. One of these requirements is originality. In this context, it means that the work of art must have originated from the author. To determine if the work originated from the author, the sweat of brow test must be used to establish whether the artist created the work using their own labor, skills, and judgment. Essentially, it entails proving that they did not copy the work from another artist.
Trademarks are used to protect a specific brand, name, or symbol in terms of the Trademarks Act 194 of 1993. It is recommended that jewelry be protected through the use of trademarks only if it is possible for the design to extend to the brand identification. For instance, in the picture, Tiffany & Co. is a brand that is protected through a trademark. The disadvantage of this means of protection is that in terms of the Trademark Act, before something can be trademarked, it must be ensured that the name is available. A more accessible means of protection for jewelry designs is the process of design registration in terms of the Designs Act 195 of 1993. This act provides for the protection of aesthetic designs through registration. Aesthetic designs include the shape, form, appearance, pattern, ornamentation, and configuration of an article, or in combination hereof. In terms of Section 20 of the Act, this protection extends to the protection from the design being manufactured and imported into South Africa to be sold. Section 14(1)(a) of the Designs Act specifies that the design must be new, which means it must not have been used or disclosed previously in South Africa, or distinctive, which means that it must not be similar to any other design published before, including on the internet. The protection of a registered aesthetic design is limited to 15 years. In addition, it is the responsibility of the applicant to prove that the design is new and does not infringe any intellectual property rights which are already in existence. Various photos or drawings of the design from various angles must be submitted in support hereof. It is difficult to prove that the right you have has been infringed, since the infringement is determined subjectively by a court on a case-to-case basis. Therefore, there is no set of rules a court follows in this regard. In addition, if the color, material, or dimensions of the design are altered, there will be no infringement of the design. In South Africa, Brown's Jewelers uses the method of design registration to protect the specific protea design of the engagement ring, as shown in the image on the slide. Previously, traditional jewelry was protected through the methods mentioned earlier in this video. However, recently, The Protection, Promotion, Development and Management of Indigenous Knowledge Act 6 of 2019 came into force. And now, traditional jewelry can be protected in terms thereof if certain requirements are complied with. The Act protects registered Indigenous knowledge and proves that such knowledge amounts to the property of Indigenous communities within the meaning of Section 25 of the Constitution. The Indigenous knowledge will be protected for as long as it meets the criteria as contained in Section 11 of the Act. There are 3 requirements that must be met for Indigenous knowledge to be registered. Firstly, the knowledge must have been passed from generation to generation within an Indigenous community. Secondly, the Indigenous community must have developed the Indigenous knowledge themselves. And finally, the Indigenous knowledge must be associated with the social and cultural identity of a specific Indigenous community. The Act also sets out various rights. For instance, the Indigenous community holding the registered right to the Indigenous knowledge will have the exclusive right to any benefits arising from commercial use of the knowledge, and any unauthorized use of the knowledge will be limited. In order for a person outside the Indigenous community to make commercial use of the knowledge, the Act sets out that a license must be obtained and other specific requirements must be complied with. The Act also sets out processes to be followed for persons within the Indigenous community to make commercial use of the knowledge. Anyone knowingly making commercial use of Indigenous knowledge in a manner that is not in accordance with the Act and that infringes the rights of the Indigenous community will be guilty of an offence and liable to pay a fine. It's important to note that this isn't a very developed part of South African law, with the legislation being relatively new and there not being many reported cases. Therefore, it is difficult to give legal advice on the topic.